Hi, everyone. Thank you for joining me for complying with New York's mandatory sexual harassment training, how to protect yourself and your business from your employees. Before we get started, I'm going to give you some basic information about our law firm and who I am, in case we haven't met. I am Jennifer Kirschenbaum, and our firm, Kirschenbaum & Kirschenbaum, is a general practice law firm. We have 15 attorneys, and we handle real estate, employment, matrimonial, bankruptcy, trust, and estate. And we handle litigation, compliance, and transactional work for a wide variety of clients. But specifically, many of you know us because of our work in the healthcare field or in home integration, alarm, security, fire. And this is some of the work that we do for those industries. But first and foremost, I would say who we represent are employers. And for our employers, employment issues come up every day, and we're faced with them. So this sexual harassment training is going to impact all of our clients, and we are here to help educate and take you through this time of incorporating new policies and training requirements. A little bit about me on why this topic is near and dear to my heart is I did hold a position at the New York State Division Commission on Human Rights, which is the office that would see an administrative complaint by an employee. And I was actually responsible for assessing these types of sexual harassment cases that are potentially going to be an issue here. That's me. I'm Jennifer. I am also the managing attorney for our healthcare department and home integration transactional department. And I oversee and represent clients in transactional compliance matters and general business issues for our employer clients. And of course, employees looking for jobs, contracts specifically, we do, but we do not do plaintiff's work for individuals for the most part. In addition to working for the administrative agency that oversees these complaints, I also had the pleasure of interning during law school for a plaintiff's firm that does discrimination cases. So I have an interesting view on how these cases come about and how many of our employees are, in fact, very opportunistic and potentially looking to extort. So I have a different viewpoint that you'll hear about on this talk today about how employers really need to do what they can to protect themselves from those type of employees that are looking to take advantage. Our firm in general is a stable of very competent and experienced litigators, many of whom have diverse experience defending employers in different types of situations, including sexual harassment. So today's agenda, we're going to walk through what sexual harassment is. We're going to go through the New York training requirements, and we're going to discuss what forms state put out and how we should responsibly use them, or if we should use them at all. And then we'll talk about some of the law-mandated changes to employee settlement agreements. If you tuned in for our earlier broadcast where we had some basic technical difficulties, you're aware that we did field a number of questions, and I've incorporated those into this presentation so that way everyone can benefit from what's already been asked. So understanding sexual harassment. Sexual harassment is any unwanted verbal or physical sexual advances. Sexually explicit statements, remarks that are offensive or objectionable to the recipient, harassing conduct which is directed at the recipient because of the recipient's sex. Now, what's important here, which our graphic displays, is that perception is what's important, not actual reality, because perception is reality. So whether you intended on being lewd or you intended on being crass is not the point. If there is a comment that is made that makes an employee feel uncomfortable, the state is arming them with resources to potentially cause an issue. What that issue is and what it means expense-wise for you, that's a different story and a different topic. So category examples of sexual harassment. A physical assault is an easy one to pin on. There's an actual touching. Pinching, grabbing, brushing, these are all things we understand. Unwanted sexual advances or propositions. These may be harder to read, but they may be a request for a sexual favor or a subtle or obvious pressure, possibly for a date or for attention. Some of these are harder to read, but this is also a category of sexual harassment. Sexually oriented gestures, noises, remarks, or jokes, possibly displaying pictures that are of a sexual nature or demeaning or pornographic. Quid pro quo harassment, meaning you'll get ahead if you go out with me, that type of thing. These are all categories of sexual harassment. Hostile acts because of a person's sex, bullying, name-calling, sabotage of work, damage to workstation. These are all things. Now, this is an illustration, I love this photo, of perceived sexual harassment. This gentleman may think that they are friends, they may have gone out to a drink together, they may have some nice kibitzing going on in the office, but clearly she is not on the same page as him. She does not understand why his hand is on her shoulder, and she is uncomfortable. So this is considered to be sexual harassment. And she may feel that way. He may have no idea what's going on. But the reality is that now in New York, which is mandatory, and I would recommend in all other states, wherever you're practicing, we should have a policy, that if she were to make a complaint because of this scenario, that she felt uncomfortable that Steve put his hand on her shoulder, there would have to be action taken. A point in time, a marker has been set where Steve now has to be essentially reprimanded, that we are a zero tolerance workplace and that touching of other employees is not permitted. And we would need to document this and put it into Steve's file. He would have to be presented with it, and we would have to show as the employer that we have taken care of this. If this is Steve's company and Steve is the one who is perpetrating this, then he would have to take notice that a complaint was made, and he would have to show some sort of corrective action. So this is what we're talking about here, is implementing policies to protect and to help our employees understand what they're responsible for. The New York training requirements we're going to go through so you understand. Of course, we are offering training solutions because, as we'll get to, I am very concerned about some of the rhetoric that is contained in some of the free policies that are available through the state. I do not believe that they are employer protective because there are elements that are required in the policies which can be captured in language that is less as influential for the employee, or I'll even say empowering for the employee. And I don't believe that there's any reason for employers to adopt additional information that would enable employees to make a complaint. So this is what we're offering. This is essentially to cover our time just to help implement for you. And if you have any questions specifically, you can call Taryn, and we'll come back to this slide later. Training requirements. We are required to adopt an employer policy for training, and we're going to go through some timeframes for this. We're required to disseminate that policy. We are required to have a complaint form, and I recommend that you have an employee acknowledgement form, that the training occurred, and not only that the training occurred, but that the employee acknowledges they will be held personally responsible for malfeasance or misconduct, any inappropriate behavior whatsoever. And without the acknowledgement form, you are not going to have an avenue, unless it's in an employment agreement related to this topic or otherwise, that the employee will be responsible financially, potentially, if there is a violation of the employee's responsibility under the policy that's being disseminated or otherwise. So I want to use the acknowledgement form as a vehicle to shift responsibility, essentially by contract, on the employee for his or her conduct in the office place. Because the employer, at the end of the day, through theories of what's called vicarious liability, is responsible for the conduct and actions of their employees on site. They are also responsible, pursuant to this law, for the actions by their independent contractors, any 1099 vendors. If they are harassing employees, once notified, it is the employer's responsibility to rectify and to cut ties or remediate, if possible, any type of harassment in the employment realm. So just so we understand, it is the employer's responsibility to create a zero-tolerance environment and to enforce it. Our policy requirements are, it is supposed to be adopted by October 9th, 2018. It must prohibit sexual harassment. Now, this language of prohibiting sexual harassment is likely in many of your employee handbooks, But we are now taking that language and we are extrapolating it out into its own policy, and we are providing additional information to the employees that is required by New York State law. We have to give them examples of prohibited conduct, which can be limited. It does not have to be extensive, the way that the state is drafting. We have to address remedies available to victims. Now, the remedy being reporting, and that there is an administrative agency that is available to hear complaints. So we must tell the employees that the employer is available to review concerns, and also we have to tell them that there is an agency under the New York State regulatory scheme that's been set up specifically to hear complaints. And employees have 1 year to file with that agency from the date of the happening of the harassment or other discriminatory conduct. We are required to include a complaint form. Now, we'll get to the complaint form in a minute, but I have concerns about the draft that's being issued by New York State. We are required to give a procedure for timely and confidential investigation, which the employer is required to undergo if there is an instance. We have to contain rights of redress and all available forums. Now, again, this is going to be where they can file and seek remedies for the harm that is done to them, which could include damages. And the New York State is authorized to award damages as against employers to punish them for sexual harassment conduct. The policies also have to address acts of misconduct and say that sanctions will be enforced, including an up to termination is what I would put in there. Retaliation is also documented as unlawful. So if we have an employee who's complaining about us, we are required to tolerate them as they continue their work for the company. You cannot retaliate. Now, that doesn't mean that an employee has free reign and can violate procedures and other policies if they have complained about sexual harassment. And this is where you really have to get on the phone with your employment attorney. For many of you, that is our office. And we need to properly document misconduct by employees and make sure that you're not tolerating an insufferable situation where you are continuing to employ an offender that is not following company procedure, possibly taking advantage. We see this all the time. We recently had a case where an individual was just complaining and also at the same time was trading stocks during the day at her computer and refusing to do any of her job responsibilities. Obviously, you cannot maintain a job that way, and we have to take appropriate action and properly document misconduct and terminate. So retaliation is not the end-all, be-all right of an employee to not do their job. So I just want to keep that at the forefront of our minds when we think about retaliation. Still have to perform their job services. The sexual harassment policies have to be disseminated in writing. They have to be in a language spoken by the employees, and they have to be clear that having them does not constitute a defense to charges of unlawful sexual harassment. So just because we have the policies, we're not going to be safe. But what it means to have the policy is to show a pattern of compliance by the employer and to also have in place a clear delineated procedure if there is a complaint of sexual harassment, and we need to make sure that we follow it in each instance. We cannot self-select when we're going to enforce our policies. They have to be enforced across the board the same for everyone, or you will really open yourself up for potential liability. I want to discuss the free forms that are available. The forms that are available are going to be arming your employees with certain information. It's statutorily required that some of it be in there, but the wording of the policies can vary from what is in the model draft. They are just draft policies that are model. They do not have to be adopted totally, and I'm going to show you a piece of the complaint form that I will give you an example on how it can be drafted differently. But your employees must be armed with the right to file a complaint to their employer and the New York State Division of Human Rights within 1 year of the alleged discriminatory act. So this language has to be in there, but it doesn't have to be first thing on the page, and it can be controlled in how it's presented. We have to say that they have a right to be safe from retaliation when making a complaint. Also, again, does not have to be bolded. Guaranteed a workplace free from sexual harassment. Well, that's clear. We know that. That's part of the policy. There's a zero tolerance, so we can say that in there as well. Employers are required to inform employees how to report sexual harassment or other discriminatory conduct. So as you can see, there's a theme. It's a bit duplicative, but this is what the state is requiring that the employers actually give to the employees. Now, this is a sample New York State complaint form that is free online. You will see that it clearly talks about your complaint of sexual harassment is made against title, work phone, okay, relationship, who is it? Please describe the conduct that is the basis of this complaint and your reasons for concluding that the conduct is sexual harassment. Please use additional sheets of paper if necessary and attach any relevant documents or evidence. Dates sexual harassment occurred. Is it still continuing? All the names of witnesses. So what I see here, and it goes on and on, it's about 3 pages, is the complaint form, in my mind, is leading the employee to form a successful case against the employer. It's even instructing the employee on how to do that. You need witnesses, other people. Have you tape recorded anything? It doesn't say that in there necessarily, but do you have any other relevant documents or evidence? They're telling them they have to compile evidence. So none of these things actually have to be in here from a legislative perspective. We could hand the employees a stripped down, 1-page, fill in the blanks type thing and not help them make a case against you. So it's important from my perspective as the attorney that is seeking to protect you that we do not arm the employees with anything more than we need to. Because, and I love this photo, empowered employees feel powerful. And that is what you need. Last case, like a hole in the head, is empowered employees that are looking to feel powerful as and against you. What we are looking to do is to have quality, loyal employees that should be comfortable knowing that they will be in an environment free from harassment, and they will be encouraged to report any conduct that is not appropriate by their colleagues, peers, or bosses, and that we will be able to handle it internally. But we are not looking for troublemakers that are going to be enabled and encouraged to file costly and anxiety-ridden complaints to state agencies. So there's a difference about having a congenial work environment versus having one where the employer is held captive by the employees and afraid of their employees. And I know many of you, unfortunately, know what I'm talking about. So can I use the free forms online? Sure you can. Of course you can. That's an option for you. Is it the right move? No. I know for my business, I will not be introducing the free forms online. I will be incorporating employer-centric concepts, and I will be drafting language that is explicit. It will comply with the statutes, but it will be tailored that is appropriate for employees to receive. And I recommend that all of my clients do the same. Sexual harassment insurance. Yes, employment practices liability insurance, which is typically a rider to your general liability policy, will pay for typically the cost of defense if you are sued or there is a complaint of sexual harassment as against you as the employer. Now, what EPLI does not cover, it does not cover any amount of settlement due to the employee or damages. So that's a big deal. But the cost of defense itself can be cost prohibitive. So it's a good thing to have. It's typically not that expensive, and I would recommend asking your insurance broker to look into it for you. Law-mandated changes to employee settlement agreements. If we have an employee who's making a problem, a lot of times it's cheaper to just try to, I'll say it, pay them off. And in these agreements, there's critical language that we're looking for, which is 1, that we'll get a general release so the employee cannot come and sue us. And 2, that the employee is not going to go blab around town about what they perceive to have been harassment. So what's changed? Well, the law now explicitly excludes arbitration provisions that require an employee to waive due process rights, meaning we cannot force an employee to agree to arbitrate as a final adjudication and thereafter not be subject to independent court review. So what does that mean? It means that from my perspective as the attorney drafting, I cannot have a final and binding arbitration provision in a settlement agreement with an employee. Now, that's okay. That doesn't mean that I would forego having arbitration in this type of agreement because it's generally a cheaper forum than court. But it may have to be drafted a bit differently. Same with our agreements in general, because now for us to have non-disclosure in a settlement agreement, which is the whole purpose of the agreement, we need to document that it is the preference of the employee for the inclusion, which is not a big deal. We basically put into the agreement that the employee wished to sign this agreement specific to the employee's request. This agreement requires that the conduct not be discussed about, or the reason why there is an agreement or the settlement we're entering into is going to be confidential. And in addition to that, many of you may be familiar with this type of time frame we're going to talk about now, because we have to have it when we do an employee release. And we seek a release from an employee that we're terminating in exchange for severance. In our typical severance agreement, we are legally required to give a 21-day consideration period. So we tell the employee when we give them the agreement, you have 21 days to think about this. And then from the date that they give it back to us signed, they have 7 days to revoke the agreement. And that language, again, is used in other instances in this state, in New York, and many other states, when you're asking an employee to waive their rights. And the reason why this has been put into place by a matter of public policy in many states is because the employer is dealing usually from a position of power, and they're trying to give the employee plenty of time to consider, possibly retain counsel, and understand exactly what it is they are waiving. So I don't view this as much of a hurdle, but I understand it slows down the process for cleaning up a potentially messy situation that you're looking to get rid of, but not the end of the world. Now, any payment would not be made to the employee until after the 7-day revocation right has expired. So we went over it before, but these are the basic training options that we're going to be offering, and these are the flat fees that we're doing it for. You can order online at www.shemployeetraining.com, and what we would do is for the policies, if you would like specifically drafted and protected policies for your business, and this is required for all businesses in New York, and we'll get to some of the recap in a few minutes. The policies, an updated complaint form that is much more innocuous than what's being offered by the state, and we will put together an employee agreement or employee acknowledgement for the policies that will cover the employer and will serve to provide some additional contractual rights to the employer from the employees. We are also happy to do live webinar training for you and your staff to adhere to the deadlines, which we'll go over again. And you would pick the day and the time, and we'll provide live training session for your staff by one of our employment attorneys, either myself or one of my colleagues who specializes in this. And your employees, which is required, will have an opportunity to ask questions live on the webinar. And the cost for that is $450. We will speak with you before, find out what your issues are, assess, and address on the call. We will also be available for questions after by employees as necessary. We'll record it. You can use it later if you want. There is a requirement to train all new employees, and we can make it clear that they can ask questions to our office if necessary, or directly to you with the training, because you are required to do live training. But for many of us, that's going to be very impractical, and we'll talk about that more. So in addition to ordering online, you can also contact Taryn or me, and we can help put together whatever you need to help with your business. The note here is scheduling constraints require we know in advance of our training commitments prior to the year-end deadline. So please be sure to book and reserve of course, giving the pricing, payment is required in full. Now, disclaimer down here is worth noting that the adoption of a policy does not constitute conclusive defense to charges of unlawful sexual harassment. We talked about this. Just because you have the policy doesn't mean you didn't do it. Well, or you didn't allow it is more important for me to say. Because if you have other employees that are harassing, you need to stop that conduct immediately, because as the employer, you are responsible for the conduct of your employees. So these were questions we received earlier. I think they're very helpful in hammering down exactly what it is we need to get to. So I'll go through them. What about 1099s? Now, I did speak about this briefly before. Much of what we're going to cover now is just a recap. 100%, the new law is explicit that the employer is responsible for protecting all employees from 1099s as well as their colleagues who are W-2. So if you have a tech or you have a consultant who is brought on a 1099 basis that is interacting inappropriately with your staff, calling in from working outside, et cetera, you are responsible to protect your staff from that person. And if there is a complaint that is up the chain, that is made and known, you are 100% responsible to act on that by writing up, terminating a relationship, remediating, 100% responsible. How much documenting does an employee need to prove harassment? This is a good question. It depends. Depends on what the charge is, and it depends what they have. But I can tell you from my perspective, having worked in the office that's reviewing these things, they need to be able to corroborate, so they need a witness. Now, what's the problem with that? You might have 1 or 2 or 3 people that are in your business that are in cahoots, and they're happy to take you down. So for that to be the case, we need to make sure that we are in line with our employees. We understand exactly what's going on in our offices. We have our finger on the pulse, and we want to be careful that we're not being recorded. We want to watch for possibly cameras. I mean, a devious employee may do a lot of things to pull plenty of tricks. So if you are having a problem with that, where you think that you are possibly under surveillance, please make sure to speak to your attorney very, very quickly. You can call us and we'll be happy to boil it down. But remember that once you're aware that there's a complaint made, if you fire, you will potentially be opening yourself up from a charge to a charge of retaliation, which is a serious charge. And we also don't want to see you stuck with an employee who's causing issues for you. Can I get sexual harassment insurance? We talked earlier about this. Yes, sort of. It generally covers legal fees, but not payouts. So it's called employment practices liability insurance. It's a rider, your general liability. Talk to your insurance broker ASAP and make sure that you do have it. I have 2 employees. Do I have to train? Yes, it applies to all New York employers. All. Oops. Everyone, no matter the size. Yes, you have to train. I'm sorry. Okay, we have 150 employees that would have to be trained in shifts. Instead of a live webinar, could we have a recording to show our employees, and then our HR specialist can be available to answer questions? Well, I am comfortable with this because just from a practicality standpoint, it is going to be absolutely impossible to train everyone at the same time and everyone in a live training session, because remember, every single employee that you have in that's new has to be trained within 30 days on sexual harassment. And we're going to want them to sign off on an acknowledgement form or an agreement that they've received the training. And then they're going to have to be able to ask questions about the training. So I'm very comfortable with this, that we do a recording and that you utilize that recording. We make it clear that there are specific people available to field questions. And remember, the fact that an employee is trained or you're doing the training and that you have a policy in itself is not going to absolve you from liability if you are sustaining an environment of harassment. So what does that mean? What is the employer's obligation really? If you have an individual who is behaving inappropriately, who's a little fresh, a little crass, that individual has to be addressed immediately. That's the reality. And you have to go by your policy that you have internally. They need to be written up. They potentially need to be terminated. And that should be assessed with if you have an HR specialist or with your attorney, and it needs to be done immediately. I got this question earlier. Yes, I am married, and I have 2 sons, Owen and Samuel. Many of you guys know that because you get my newsletter. What time frames do I need to know? You need to know October 9th, 2018, policy adoption. Best case scenario, you adopt by this date. If it doesn't work out for you, you don't get your act together because of some of the other questions we have coming up, that's okay, but this is the deadline according to the legislation. You're supposed to have it in by October 9th. By January 1st, 2019, all current employees are required to be trained. 30 days from new hiring, you are supposed to have training requirements met. 21 and 7, this is a time for consideration for a non-disclosure agreement with an employee that is complaining of harassment, and you have 7 days for a revocation consideration period. So these are the time frames that you need to know right now, and any questions, you can always call our office. Can an employee hold the employer responsible for harassment by another employee? Absolutely. This is the concept of vicarious liability. The employer's job is to maintain a zero-tolerance environment for harassment, and you are required to maintain a harassment-free zone, a discriminatory-free zone, not just sexual, but in general. You cannot maintain a hostile work environment and discriminate against employees or allow a situation of sexual harassment. So the employer 100% will be responsible. Do I need to tell my employees they can report me to the state? Yes. The legislation requires for your employees to know that a complaint can be made to the New York State Division of Human Rights. So that is unfortunate that we have to give that information and arm with our employees, but 100% it is required. Is verbal abuse considered sexual harassment? Well, it depends on what you're saying in the abuse and how uncomfortable you're making employees feel. I will tell you, though, if it doesn't qualify as sexual harassment, if you are verbally abusing employees, you may still be creating a hostile work environment, which is also actionable and reportable to the same exact office that sexual harassment is reportable to. So I didn't make up the questions, people, I'm just answering them. Is calling someone sweetie or honey harassment? It depends on the perception of the employees. Some employees may feel that's endearing. Some employees may recognize that their boss is old school and believes that that conduct is actually acceptable and endearing. Again, it's all a matter of perception. I would say that even though many of us work so we can have employees and provide for them so they can provide for their families, most of our employees do not appreciate that. And, well, in general, they just don't appreciate that. And they don't care that you want to feel comfortable at your place of employment as the owner. And they will hold you to the standard that they believe objectively should be enforced, which is what these policies are about, treating everyone the same, having conduct be the same and above board. And so if you are calling someone sweetie or honey and you haven't gotten the message yet with what's going on politically, I'm going to say it to you again, you should probably cut that out. How do you confront the harassing employee? Well, this is a good question, and a lot of times it depends on the situation and what the level of harassment that's reported is. Is it redeemable? Can this person be dealt with and remediated and kept? Or is it so revolting that this person has to be terminated immediately? So I would say the first thing you have to do is assess the situation, which is what your policy is going to require. And then we determine exactly how or what ramifications there should be for the action. Is this employee going to be sent home with or without pay, docked to think about what they did? Is this person going to be able to remediate, or does this person have to be fired immediately? And depending on the course of action would depend on how to confront. Now, you do not need to do this alone. If you are a smaller employer and you have an office manager you would like to bring in on this, or if you are confronting the office manager, and you want a third party and you need counsel there, this is for mostly New York training, and most of you are fairly local. If you need us to come out, we would be happy to do it. Or if you feel like you have a witness available on site, I would recommend always having a witness, someone who can corroborate what happened when you sat down with a harassing employee, and you're going to want to document everything carefully. So if you want help with the documentation, any which way you need assistance, you can always let us know, and we'll be happy to make sure that the situation is being handled properly. Why didn't the state notify us about this? I shouldn't have to comply. I couldn't help myself. It's late. I had to put in this visual. Okay, sure. The state did send out a lot of emails, and from that, the bar associations have blitzed the attorneys, and the attorneys have blitzed the public. And yes, I'm sorry, you will be held to the same standard, even though this is the first that you're hearing about it. So every employer in the state, no matter the size, has to comply. So I think I covered this enough. If you have any questions, you can always contact me directly, or if many of you are familiar with Ken, you can contact Ken directly, or Taryn, and we are happy to help with your training. Just let us know. You can, if you're not in our newsletters yet and you want to be, here is the link for our website, and I think I put my contact information again. I did. So that's me. Here's my email address. Here's my number. And if you have any specific questions about what I covered today in the webinar, feel free to please give me a call, and we are happy to help.